Very interesting, very concerning case in which orders were very recently passed, and I have a lot of observations, a lot of thoughts about this case. I just went through this briefly, but I wanted to kind of think aloud while going through this because there are so many lessons for divorce lawyers in this kind of a situation, and also sheds very unfortunate light on the direction in which the divorce jurisprudence of this country is going. So this is this judgment, Shivangi Bansal versus Sahib Bansal. It's a transfer petition filed in 2023, and the court goes on to describe how the wife was seeking transfer of a case from Principal Judge Family Court to one court at Hapur in Uttar Pradesh. The other hand, the husband filed a transfer petition seeking transfer of a case arising out of an FIR lodged in 2018, pending before Additional District Judge Hapur under the DV Act, pending before Hapur Court, and he was wanting the case to be shifted to Delhi. One other thing is, can husbands never file a transfer petition? We've had a lot of cases where husbands can and have, in certain peculiar circumstances, gotten the relief of the court having transferred the case from one particular jurisdiction to another. Now, additionally, there were many cases which were dealt with by the court. Was many interesting observations that I have on this. Now, there was an appeal against an order passed by the Allahabad High Court. Now, in this, certain appeals were there. I think both parties appealed against certain orders of the Allahabad High Court, and now the court goes into the facts as follows. Married in 2015, one daughter, born, presently 8 years old. After marriage, resided in Delhi, and for Delhi for till whatever time, and they separated in 2018. After separation, parties have filed several cases against each other and their family members. Now, cases filed by the wife against the husband and his family members and relatives. There are 15 cases filed by the wife against the husband. Then cases filed by the husband against the wife and her family members. There is, FIR, then there is another FIR, then there is a criminal complaint under section 200, which I keep telling husbands you should do. Defamation under sections 500, 501 IPC. Then there is a divorce petition, which I personally feel is mostly is useless. A writ petition filed challenging the IPS candidature of the wife. Now, interestingly, wife here is an IPS officer, and I would say it is sound legal strategy for spouses in a legal battle to go after not just the law or availing of the civil and criminal remedies. There are other ancillary things going on the side. For example, we had this one client who was fighting out, and we were representing the client in the divorce case. Now, the wife had some connection with the MCD, and the MCD, was after many months of, the client getting a stay order getting vacated, something with the monitoring committee. And then the wife got the MCD to seal his shop. And because of that, the client said, this is my source of revenue. This is my worship. This is my temple. I can give my wife what she wants in terms of extra money, but I cannot be having a single day that my shop is sealed. So everything else we won, but because his shop got sealed, he settled. Then we have another case where the husband found out that the wife had a fake doctor's degree, because when she says she was studying abroad for a particular degree, he had proof that she was actually living with her inside India. And so, that was used as leverage to negotiate a far better, arrangement. Now, in this case, they registered another FIR here, a guardianship case, transfer petition, then an SLP against Allahabad High Court order rejecting a criminal revision, and then a civil special petition against a maintenance order, which was also passed, which we'll get to. Now, additionally, there are incidental matters cases proceedings filed by third parties in view of the matrimonial discord between the parties. Complaint case number so-and-so, another FIR by so-and-so, by an advocate in Hapur, UP, right? Under the SC/ST Act. Beautiful. So, wife living in Hapur, wife presumably IPS officer posted in Hapur, and there is an SC/ST Act case by an advocate in Hapur, presumably against the husband and his family members. And what was the impact of that? Maybe perhaps this, maybe something else, because we are only working from presumptions. I have never dealt with any of these cases. We can just hope, we can just or we can just we can hypothesize. Complaint case so and so, section so and so, so and so, and SCST Act at PS Hapur Nagar. Then a defamation case filed by some person before the court in Hapur. Then a land dispute between so and so and so and so pending before the civil judge. Land dispute between so and so pending before district courts Aligarh. The court says then both parties wish to amicably solve all disputes, settle all this thing. Senior counsels appearing. Separation of the parties 2018. Their daughter under the custody of the mother. Is an order that the mother shall have the custody of the child. The father and his family have supervised visitation rights to meet for the first 3 months, thereafter based on the comfort well-being of the child, etc., etc. The next thing is the wife has voluntarily agreed to forego, waive her claim to any alimony or maintenance from the husband. She'll have no claim over any properties. The reason why I feel the wife has agreed to waiver is something that we'll see a little down below. Wife has agreed to take all of the expenses of the daughter, does not want any maintenance amount. The order of maintenance of 1,50,000 per month passed by High Court Allahabad, Uttar Pradesh, directing the husband to pay for the wife for the maintenance of the child shall not be executed by the wife and is hereby quashed. So 1.5 lakh rupees is a maintenance order. A lot of times husbands come to me and say, what's the maximum that the court can fix? This is maintenance only for the daughter. So if you think that the amount will be fixed qua the needs of the child, when the mother is an IPS officer, so presumably she should have an equal right of responsibility. So technically, if we are doing a fair analysis, it should transpire that the daughter must be having expenses of 3 lakh rupees a month, and then 50% of that the father has been ordered to pay. But in this country, at least I can imagine that for a minor child, 3 lakh rupees a month is not the proper expense. It is just because the father, I'm presuming again, right, there are certain presumptions we make as divorce lawyers because we see patterns. Presumably the father was having a decent income, and that is why the court did not say we'll fix the expenses of the child. It is almost in a sense a punitive imposition where the court says, okay, you are earning, say for example, you're earning 6 lakh rupees a month. So 1/4 of that seems to be a justified amount to hit you with, so that you can go out of court because you're forcing us to apply our mind. And so 1.5 lakh rupees for half expenses for the child is something that he was hit with. Not that I know any of the parties, full disclosure, I have not consulted, talked to, I'm not trying to, be like representing the husband or talking about his interests, nothing of that sort. I'm just pure my observation based on what I'm reading and with the things that I have seen in these cases. To bring an end to the protracted litigation, so and so, all the cases are quashed, all the incidental cases are quashed. There are no other proxy proceedings. Everything, if they have filed, should be taken back. They will not initiate any future cases. All allegations withdrawn. The undertaking will not meddle. Now, remarks, observations made against the wife in the final judgment order dated 13/6/2022 passed by the High Court Judicature are hereby expunged. And this is something that I had missed out on before, and I would love to see precisely what were the observations, if I can try to find them. Well, it seems like internet searches have eclipsed, the recent Supreme Court judgment has eclipsed all other prior mentions. Yep. So I'm not able to find that order, but I am assuming the reason why the Supreme Court down below mentions some things that that had something to do. Now here's the thing, this is very interesting. I don't know the context, but I'm again thinking the portions down below have something to do with this. The lady's mother shall transfer property situated and so as a gift deed to the husband, and all expenses for the said transfer to be borne by the husband. Transfer of the said property shall be done on as is various basis. There are litigations with respect to the above mentioned property, and he shall step into the shoes and bear all related expenses. Okay, that's just, procedural stuff. Now, this is interesting. The lady shall never use her position and power as an IPS officer or any other position that she may hold in future position and power of her colleagues or superiors or other acquaintances anywhere in the country against the husband, his family members, relatives, by way of initiating any proceedings before any authority or forum through any third party official, or causing any bodily or mental injury to the husband and his family in any manner whatsoever. Clearly indicating that some foul play definitely took place. This lady apparently, very clearly, that's the reason why the Supreme Court had to use this observation, clearly abused her power. And another reason why we say clearly, because there's something else that has been observed by the court. And so, for us to say that, that power is not misused. Now, it is unfortunate, and obviously, if the lady is in herself a position of power, it becomes very apparent, right? Because of which the court can come in and say, how dare you abuse your power? But what about those lakhs and lakhs of cases where, not even just the wife, but even the husband, right? In matrimonial disputes, in other disputes, there is so much of this nonsense going on, which is that I know an IPS officer, I know an IAS officer, I know some politician, and because of that, my life will now be made hell, because false cases can be, my opponent's life can be made hell, because I can get these people to, on any nonsense, frivolous, baseless, without evidence, I can go and just attack, and what the court says, the next paragraph itself is, as a result of the cases filed by the wife, husband remained in jail for a period of 109 days. This is on top of the 1.5 lakhs maintenance monthly that he was asked to give to the lady who got him imprisoned for 109 days. And his father for 103 days. So the husband spent 109 days in jail. Father spent 103 days in jail. And the entire family suffered physical and mental trauma and harassment. Now, maybe, for hypothetical sake, they did commit some of the atrocities that she complained about, and therefore the police genuinely stepped in and took them into custody. But if that was the case, if there was the slightest possibility of that happening, the court would not have mentioned that what they have suffered cannot be restituted or compensated in any manner. This lady and her parents shall tender an unconditional apology to the husband and his family members, which shall be published in the national edition of the renowned English Hindi newspaper, published, circulated on all social media platforms like Facebook, Instagram, YouTube, and other platforms, shall not be construed as an admission of liability, shall have no bearing on legal rights, obligations, or consequences, but shall be published within 3 days. One very interesting observation is the power of social media now, where the court says not just newspapers, but on your social media as well. And the court says above apologies made to bring about amicable closure to the protracted legal battle and associate emotional and mental stress without prejudice shall not be used against the lady before any court, etc. Then now this, as the matter is being settled by this is the power of the internet, right, which even the courts of law cannot ignore. As this matter is being settled by the present order, all allegations made by either party, their family members, their representative against each other on various social media platforms, including interviews, statements by the wife or husband that directly allege against each other and or their family, shall be deleted from the web. Just today in the morning, I was consulting this client who said that his wife, did a lot of hue and cry, and then she had attacked him. So he shared the video of her attacking him when she left the house. He shared the video of her attacking him with something and thrashing him. He gave it to a news channel, and then that news channels put it up on their website, I think their YouTube channel, and that she knew that a lot of people will be attacking her on the internet. She thought, let me try to make peace and get back inside the house of my husband. So she tried to forcibly enter the house of the husband, and the husband tells me, because he had consulted me many months prior, that he was he told me that I gave him the exact step by step script of how this whole movie is going to play out. She's going to show up with police officers, and she's going to scream and shout, and the police are going to say, how do you not let your wife, who has a right to reside, how can you not let her come in? And then he said exactly what I've told people to say on the internet, and he said that that it pulled out beautifully, and he was able to restrain her from coming inside the house. Anyways, each party undertakes not to publish, disseminate comments, negative defamation, etc., etc. They'll abide by the above terms, and then the court uses its powers under Article 142 of the Constitution for dissolving the marriage. On that point also, when a couple of years ago the Supreme Court came up with this judgment, it said that the court can use 142 Constitution to dissolve a marriage. A lot of people started coming and saying, sir, mera bhi 142 mein karwa do. But I explained to them that the Supreme Court judgment, if you read it carefully, itself says that we can, if an litigation is ongoing in front of us, say a transfer petition or an appeal, etc., then we can, in the right circumstances, use this power sparingly, but you cannot directly come to us under 142 and say, give me divorce because my spouse is a psychotic person, right? So this is one of those cases, a couple of transfer petitions, a couple of appeals, and then the matter goes before the Supreme Court. And I've seen this happen way too many times, and you search on the internet, you'll see this happen many times, that when a matter is pending before the Supreme Court, all of this herogiri, this rampant abuse of the process of law kind of is halted by the court. And when the court sees this little gutter show taking place in front of it, the court says, at least we have the power, and we know that no other appellate court judge is going to look down upon us and reprimand us. We can at least choose to do justice and do things like this, which, if I guarantee you, if this was not done by the Supreme Court of India, and if half of these directions were passed by any state high court, any of these spouses would have appealed this before the Supreme Court, and boom, there would have been instant stay on the judgment of the High Court. It is only the Honorable Supreme Court of India which can pass such detailed, specific, and, might I dare say, opinionated judgments in a situation like this one. And I say well-deserved so. But it is only the Supreme Court which can pass such opinionated judgments and not face any consequences, because it is the Supreme Court. And how many times I've seen that a High Court judge will go out of their way to try and do justice because they're seeing so much of injustice happening, and they have faced the consequences of the Supreme Court coming down and saying, how could you pass an observation like this? So I'm happy that things like this happen. 1.5 lakhs per month for the daughter after spending over 100 days in jail, your father spending over 100 days in jail, SC/ST Act cases, all of that. And then ultimately, it is only the Supreme Court which came to their rescue and dissolved everything. And by whatever reasons, no alimony demanded, no child support demanded, some transfer of property situation going on. We can only imagine what was going on in all of this. But one thing is for sure. This very unfortunate observation that I wanted to really talk about as well at the very end of this video is that there have been so many reportings. There's just one, and I was shocked when I read this in the morning. I woke up and I read, Supreme Court says no automatic arrest and affirms High Court judgment. But what is the judgment? There is a one paragraph which I honestly don't think will have any binding value, and I really think that police officers around the country will still, if they want to, in those few % of the cases that they feel like we're the boss, we can do whatever they want, cops can still go and arrest a husband. Because what these lines? They are apparently binding all over the country. No, I don't think and I don't know how it's going to be constituted. I don't see, to what extent this has to be discussed in detail in subsequent judgments by perhaps other judges or by the same bench, because there has to be more clarity. Apparently, the saving grace, after 7-8 years when the Supreme Court earlier tried it. A 2-judge bench fixed this family welfare committee thing, and then a 3-judge bench led by Justice Deepak Mishra overruled it. This particular order is a little vague and ambiguous, and I don't think it will have a lot of enforcement for the next couple of months. And perhaps, hopefully, there will be more clarity, and perhaps, hopefully, which I completely strongly agree with, husbands should not be automatically arrested in dowry harassment charges. I say, if he's guilty, after holding a trial, send him to jail. But for God's sake, why do you need custody of a man if a woman goes and says that he harassed me for dowry? Okay, he did. Let him go to jail if found guilty. But why do you need to take custody of him when an FIR is registered? Why do you not send him to jail once he is found guilty? What is the threat faced by the wife or by the criminal justice system that him being out is a problem for us? So yeah, the order says, the last paragraph, which I think has been wrongly reported. Transfer petitions, especially petitions, are disposed of in terms of the above order. Guidelines framed by the High Court of Allahabad in impugned judgment dated so-and-so. Wide paras 32 to 38 with regard to constitution of family welfare committees for safeguards regarding misuse of section 498 IPC shall remain in effect and be implemented by the appropriate authorities. I think this needs further explanation by the court, because unfortunately this 13/6/2022 Allahabad High Court Constitutional Family Welfare Committee for safeguards regarding misuse of 498A judgment was passed between these two parties. So I don't know exactly what was the thought process of the court. I feel it's a little ambiguous and needs definitely more clarity. And I would say to any husband thinking that, oh, now that there is a news report which says that the Supreme Court has said, please let's not be completely rest assured unless the police themselves are also in this same level of, the police officers are also on the same page, or perhaps level of misconception where they say, okay, the Supreme Court said follow 32 to 38 guidelines for the constitution of family welfare committees. I mean, whatever happens, we'll be anyways at the forefront of it all. But at least a very, very interesting case where unconditional apology, and that to the format of the apology, not just, you could be sorry, like, I am sorry, Mr. So-and-so, right? It could be one line. The court has given a whole big paragraph of what the lady and her family have to write on their social media. I think this is the first time this has happened, that the court has directed, the Supreme Court has directed a lady to write this kind of an apology letter. And, I can only hope that with more traction in the news, on the media, and in the judgments about the rampant misuse of these dowry harassment and these other laws, we'll have a little bit of more of an equitable system in this country.